Meeting to order this June 4th, 2019. Special meeting for the village council. Planning Commission.
You're doing great, Jess.
All right, fantastic. So first thing is respect to the flag. Pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So we start with the roll call.
Okay, Bama?
Here.
Curtis?
Here.
Cook?
Here.
Douglas? Absent. Helmut?
Here.
Ballard?
Here.
Pilak?
Here.
I'll make a motion to excuse Gary Douglas from this meeting.
I'll second that. I can't second you.
I'll support.
All right, so he is
Yes, all in favor?
all in favor?
Aye.
Aye.
Those opposed? Hearing none?
Is there an echo?
Very good.
Trust me, Gary was just like this his first meeting.
All right, good. So, so we're the approval of the agenda.
I'd like to make amend the agenda tonight so that we can approve the meeting minutes from 3 of our meetings. So if we can include those in the agenda, in the amended agenda, I would make a motion to approve.
Support.
Second? Oh, no, I already made it.
If you want more support, Jan, I'm good.
Right. Like I said, everybody rides their bike for the first time.
This bike is kind of seems like it's ghost riding.
Okay.
All in favor?
All in favor?
Aye.
Any opposed? Hearing none?
Now what we're going to do is we added approval of the meeting.
Okay. So we've added the approval of the meeting minutes.
Yes, I'll make a motion to approve the Village Planning Commission regular meeting minutes of March 19th, 2019.
Support.
All in favor?
Aye.
Any opposed? So motion forwarded, carried.
I'll make a motion to approve the special joint meeting of the Village Council and Planning Commission of April 16th, 2019.
Second.
All in favor?
Aye.
Aye.
Any opposed? Motion carried.
I'll make a motion to accept the special public hearing meeting minutes of the Village Council and Planning Commission meeting of May 20th, 2019.
All in favor?
Actually, there's no support
Sorry.
yet, and I have a question. Was that actually considered a public hearing, Terry?
Yes, it was, no, it's just public hearing.
Okay. Then I'll support it.
All in favor?
Aye.
Any opposed? Motion carried. All right, so back to the agenda. So the purpose of the meeting is to consider the consideration of actions with respect to the recreational marijuana ordinance. So let's see. So maybe Mario, you put together a rough draft of some timeline to help us kind of make sure that we get things kind of moving along and together. If you could just maybe quickly or go over that with us or help us to why you came up with some of these things.
Sure. Evening, everyone. So as we know, just from the minutes approved, we've had several meetings with regards to this topic. And as part of that information that we received during those meetings was from the representative from the Michigan Marijuana, I'm going to say saying that a lot, Michigan Municipal League, or MML, stating that there's the potential for the Marijuana Regulatory Authority to begin accepting applications as soon as September 1st. So what it crafted was a draft schedule that's based on a typical scenario for adoption of an ordinance. That includes everything in terms of public hearings, in terms of notice publication and in terms of if an ordinance were to be approved, how the requirements to make it effective, meaning they would have to be published and the date after the publication which is effective. Now, I should have made the draft on the top of this a little bit larger because I made that this schedule relatively quickly without the expertise from our clerk, Terry. And after discussions with her today, a couple things that affect the schedule is the fact that the council actually does do 2 readings of an ordinance prior to it being approved, and the intent for that is so that the public has, and everyone in the village has, a reasonable amount of time to consider it and have it come forward and make any comments for or against. And one other specific with regards to that is that typically it's done at a regularly scheduled meeting. The draft in front of you was an effort to show if there was enough time, how much time the planning commission would have to have meetings and discussions with regard to crafting an ordinance. So, with the revised information and knowing that it has to happen at regularly scheduled village council meetings, and knowing that the regularly scheduled council meetings are now only on the second Tuesday of every month?
Second Tuesday.
Yes, second Tuesday of every month. And then you factor in the notification requirements for those meetings. There really is no time in which the village could adopt an ordinance to regulate it prior to that potential September 1st day. September 1st is a Sunday. But prior to that day in which, in theory, the MRA could start receiving applications. So I apologize for that, not having the complete schedule in front of you, but that's just one thing to consider. And then you also have in front of you, if we wanted to even to start discussions with regards to crafting an ordinance, I just wanted to emphasize that when it comes to this body and what it's empowered with, you're empowered to do a zoning ordinance. Now, there are a lot of different aspects with the regulation of marijuana and adult use marijuana specifically. Some of them we won't know yet because the rules are still being crafted. But we do, the benefit is we do have the state statute. We have a state statute that allows for adult use marijuana, and we also have the zoning enabling act. Those things are very specific with regards to what we, with the planning commission as a body, can regulate. And that is its location, where it can be located, and also when it comes to what can and cannot be allowed in terms of the type of use, and then also how you would, or the village would go through and approve such a use, where it can be located. As I mentioned, there are other things that get regulated for marijuana uses. Those include, the background of an applicant is an extensive process that's governed by the state statute, that's governed by the rules. Other things with regards to how all of these different uses are run and operated and levels of quality. Those are all things that are controlled by the state. And then the taxation, of course, is controlled by the state and dictated to us in regards to what we can and can't charge. And it even gets down to what the village can and can't charge from an administrative fee. For example, where the maximum the village is allowed to charge is $5,000 per facility per year. But even that is not
Per year?
Per year. And even that, actually, though, isn't the purview of the zoning ordinance. In order to establish that process, there would have to be a separate general law ordinance created by council that would say licenses are required for marijuana establishments, and the village council must be the one to adopt the fees. Now, their fees are just going to, it would be a simple ordinance in theory, because it'll just say, in keeping with the Marijuana Regulation and Taxation Act. But the reason I bring all that up is to help you stay out of some of the potholes that, no pun intended, for this type of use that other communities have fallen into. They've gotten deep into all these other things that basically a zoning ordinance is not supposed to deal with. The things that we are supposed to deal with, I think, are comprehensive enough and could occupy some time for us. So for you, in the end, I crafted a memo, a brief memo that just stated right now the 7 topics that a zoning ordinance would normally address for any type of use, whether it be a marijuana use or any other type of uses especially. So with that, I'll take your questions and I can just deal with what direction you'd like us to go in.
I know we're talking about the state. Is there any idea about the expected timeline? If I turn my application into the state on September 1st, how long is it going to take them to review that application? Do the background checks? It's not going to be 24 hours.
No, it's not, but the issue, and when somebody gets into a legal issue, is the fact that when they turn that application in, typically, whenever anyone submits an application for anything, even at the village, the rules in place at that time are the ones that govern what the procedures and all the regulations that application has to go through. If someone applied to the village for something and then we change the ordinances, a week later, they got it in before that new ordinance became into effect. So that's the reason why I was trying to craft a schedule that would show the date by which an ordinance would be coming into effect. So with it, and as I mentioned, this schedule was optimistic, and it just isn't feasible with in order to adhere to the village's charter. We basically would have had to have scheduled a public hearing, the first reading of an ordinance. No, actually, no, we couldn't have, because the first reading of the ordinance would have to take place in the regularly scheduled July meeting of the council. And that needs notification 15 days prior to that date, and that needs a week before. Terry, please jump in at any time if I'm not having all the dates correct.
Yeah, well, the council did vote to go from 2 meetings to 1 meeting per month, so that's correct. The regular meeting would be the first Tuesday of July, which I think is July 11th or somewhere around there, July 13th. So that doesn't fit with the timeline. With regards to the special meeting, and this was run by the attorney too, it doesn't explicitly exclude a special meeting type of thing. It does refer to an emergency situation. So depending on what that definition of an emergency is, I can't answer that. But, you always err on the side of caution to do what you know is going to comply and not, be challenged. So that was the reason for those saying for changing your timeline for sure. It had to change because you had July 23rd as a regular council meeting, which it would not be. It would be considered a special council meeting because we only have 1 meeting a month. So the first meeting after would be, let's see, July, well, whatever it is in July, and then the next one will be August 13th. So, but also before you have, you can hear it, do the first reading, the charter specifies we have to publish as well in the newspaper. So there's a public hearing that takes place here at the planning commission level, which takes care of the public hearing requirement. But our charter still directs us to publish it, hold the first reading, hold the second reading, and then it has to be published after the second reading. So then you have X amount of days before it takes effect after the publication or after the adoption.
Does the charter say the second and fourth Tuesday?
No,
or
it does not.
No, it doesn't.
No. The charter says that you have to have 1 meeting a month.
Okay.
That's what it says. I checked.
And Terry, correct me if I'm wrong, but it also sounds like while I was under the impression it had to be regularly scheduled, in theory, under an emergency situation, we could have special meetings of the council to have that. But even if we were able to craft that from the terms of the meeting schedule, the other thing that factors into the timeline is notification requirements. If we advertise in our normal paper, the Oxford Leader requires a week prior to the publication, and I would assume we would still need at least 15 days prior to both the second reading and the first reading in order to get that. And then you also need the time after the meeting for it to become effect, which is 7 days?
Well, there's another question that I ran by the attorney, because the charter actually says 20 days from adoption.
Right.
There is law, though, that states 7 days from date of publication, because there is a referendum process that people can go through to challenge, petition, to overturn a decision if they don't like it, and it's within 7 days of publication. So I posed that to the attorney, and you know, right now, there's, you know, it still puts you in over your timeline, over the September date, drop dead date. So, you know.
So it is tight. In theory, getting with Bob a little bit more, the attorney might be able to help us craft some schedule, but you know, it's still up in the air if it's even be effective by that September 1st date. Now, obviously, we're going with this September 1st date because it's what we've heard from the Marijuana Regulation Authority. Technically, the statute says that applications are supposed to begin receiving in December. So that's another factor into it, is that we'd be trying to meet this September 1st deadline. So in terms of the schedule and in terms of, you know, when you should start your discussion about the specifics of an ordinance, you know, I mean, we could have a brief discussion now about these details, and just so you get an idea. I will say that, you know, it is going to be a controversial issue, and normally, whenever an ordinance is crafted, you know, you have some kind of direction in terms of specifics for a general idea, a ballpark area where to play for a certain type of use. So if you come up with something that gets forward to council, there's a potential that could be sent back because I'm not sure if everyone's aware of the specifics and of the zoning standards and what can and can't be regulated, and then also, you know, if they're going to like what you come up with. But I mean, that's the ordinance. The only thing is that's the ordinance creation process. You know, the purpose of this body is to deliberate those things and those details and come up with it. Try and knock one out of the ballpark on a first go. Sometimes it might work, and sometimes it might not. You might need to craft it again, but.
Seems like we only have that opportunity here.
Right, exactly. It's a very thin needle to thread.
I also think any ordinance we write is going to be amended almost immediately, because you never know what the state's going to throw at you.
Correct, and that's one thing also to consider is the fact that we don't know what the rules are, so we might have to start changing the ordinance as soon as it's adopted. But the benefit would be if we had something on the books, we would have a higher level of protection than we do now if this was to start receiving the applications on September 1st. And you know, we also the benefit of the attorney, because I'm not an attorney. The attorney would tell us answer one of your questions in terms of if the application gets submitted, you know, what is in effect at that time. I mean, that's my general experience with the situation, that it's important to have those in effect, and it's important, even though in theory special meetings can be had, you know, there's a reason for emergency situations, and so having more time, even though I know that the council would like to try to have this dealt with expeditiously, it's still tough.
Can I just make one comment on the amendment issue? You have to realize too, when you amend your ordinances, you still have to go through the same process. You have to have it published.
The whole thing.
So you're looking at another 3 months maybe, if you're, maybe 2 if you're really good, you know exactly how you want to tweak it. So you're still vulnerable during that time when whatever's in place at the time and you see something bad and you want to amend it. If that's not going to take effect until you go through all the steps again and then publish, and then that's put in.
I was thinking mostly because the state's going to change it
Right.
15 times before September 1st again.
Right.
Right,
And
that's true.
it's always going to have to be amended to meet up with whatever the state changes.
So is that smart to do it that way, or, that's the question you gotta ask.
I have another question too, Mario.
Yes.
Do you know, as far as like I guess, legal exposure in regard to amending the ordinance? Because I know this is obviously a hot topic and a sensitive issue, and there are a lot of there's a lot of special interest groups behind marijuana in general. And so I'm thinking, for example, if we had a zoning ordinance in place and then someone applied and then we amended it, doesn't that open us up to exposure for a lawsuit that, we're discriminating against them now because we amended it?
Right. Well, once again, I'm not an attorney, but from my experience, I would say that if the intent of the revision was to restrict or further dissuade an application that has already been submitted, that would probably open you up to more exposure. Whereas if you had an ordinance that was in place, and then the state passed their rules, and you say, we need to amend this ordinance to comply with the state rules, then I would think that would be a more defensible position, because you're not saying it's about this particular applicant or this particular characteristic. You're amending the ordinance to be in more compliance with what the state rules and governs. So I think that would be
Right,
there.
makes sense. Thank you. Do you know if the state rules have been, I think we said we were told to be maybe about June?
Yeah, in June, in theory, there'd be a draft out there, but it's not what I doubt they would like public release draft rules. I think it's one of those things where the gentleman from MML might be able to get a copy of it because he was in conversation, and then he'll have a big huge draft watermark on every sheet. But looking at the state statute, one of the things that might be specific to the rules is probably going to be, well, number one, it's probably going to be pretty similar to how they're dealing with medical marijuana. But then number two, there are certain things that the recreational statute allows them to have a little bit more purview over. For example, when it comes to definitions, right now, under medical marijuana, they have 3 different licenses for a grower A, B, and C based on the quantity of plants, 500, 1,000, 1,500, I think. Whereas, and that wasn't in any of the other 2 state laws. That was a rule that eventually created, they differentiated the licensees based on the amount of applications there were. In the Recreational Marijuana Act, they have a generic, all-encompassing term called marijuana establishments, and it's intended to cover any establishment that provides for or deals with marijuana. And the definition specifically says may include, but is not limited to, growers, growers, retailers, testing facilities, and other establishments which may be created. So in theory, someone in the future might have some enterprising idea, and they say, oh, I want to do this, and then they'll be like, then the state might say, oh, okay, well, we can see that, and it's going to fall under this, and they're going to change the rules, and it's going to be a different type of establishment. So that's why some of the rules that come out over time, hopefully, won't change as quickly as the medical marijuana ones have done, because they've literally been changing every month. Whereas, in theory, now that they've gone through this process, maybe they'll start to calm down. And I think we were saying that, it's been 8 years since they passed the first Medical Marijuana Act, and it's taken this long to get to this relative level of calm where everyone pretty much knows what's going on. So who knows, it probably won't take a whole other 8 years for the recreational aspect to get dealt with, but, it's going to take some time. And as it's intended, none of these regulations are supposed to be written in stone. They're supposed to, in theory, break the marketplace. Another thing that recreational marijuana establishes specifically is I think it's a micro business, in which it allows someone that has can grow up to 150 plants, process it themselves, and sell it themselves, and transport it themselves. So that's a different use. It's not under any of the medical marijuana rules or statutes. So you can see how that might be something they think that when they crafted this law, they were thinking, oh, we need to have some more entrepreneurial things, or maybe we took a page from microbreweries to think about micro marijuana, basically. So that's just an example of how the rules can change over time. But in the end, I do think that there's potential from the start. We started with these 7 different topics and addressed them. Personally, I feel that the best protect the village, I mean, not protect, the best to enact the spirit of the ordinance, but also keep in practice with good planning and zoning policies. And that's what you want to do. It's good planning, good zoning, just like any other use that we say, all right, it's important for this to go here, it's important to go there, for this to go here. Deal the same thing with this. And you say, well, we took a look at it, we're going to allow, you tell me, we're going to allow this, this, and this in, and then we're going to allow it here, here, and here, and this is what we're going to do. So please feel free to ask any more questions, because I can go into detail.
Looking at an alternative of opting out, should the council decide to opt out and the planning commission continue to work on developing the ordinance, what would you say would be a reasonable time frame to do due diligence as you just described? What kind of time frame is realistic to look at all the issues and develop proper zoning and make important recommendations?
Well, looking at the scheduling and knowing what we know about the ordinance and keeping with the spirit of it, meaning letting people have a good time to consider it. You basically have 3 months to adopt the ordinance. You have 1 month for us to go through our public hearing, and then 2 months to do the readings at council. So in front of that is all the time that we could spend discussing the ordinance. I think if we remain focused on these 7 standards, since we do have 2 meetings a month, in theory, you could get it done within 3 months, and you could be, that would be a good amount of time to discuss them back and forth. And I think 6 months would be a reasonable time frame, if not sooner, but I think 6 months would be enough to effectively do due diligence for what we have in front of us, meaning based on the statute. When the rules come into play, then we'll have to do the 6 months all over again.
Thank you.
Rose, you had a question?
No, she basically asked what I was going to.
Gotcha. I kind of had, so based on kind of what I'm hearing, and based on, we're not here to make the rules, right? Or we're not here to basically change direction. Basically, the village council has given us a direction that they're asking us to put in the ordinances in place, right? We can't undo that here. But the other thing that we can't undo or can't change is the state regulations, what they are or what they will be. So that's kind of a constraint that we have. And then, but what we do have control of is what we want in our ordinance, right? What we want, which is best for our community, what's best that we think will be best for our community with basically the direction that we have. So, there's certain things that we have in our control that we can help make what's best for us, I would say. And so maybe my thing is that if we do have to, we have the chance to maybe start the process, and if it does change sometime down the road, at least we're, based on what Mario's saying, is that we could put something together in 3 months. And one of the things that we do, I believe, that we have in our control is we can choose what the 6 things we are in our community, what we have or what we have the option to have, such as we don't have to have a grow operation in our community. We don't have to have a laboratory in our community. And we can choose, let's say if we do want a dispensary, we can choose if we want 1 dispensary. We can choose where in this map that we want that to be. Or we can say, hey, we want 1 micro business within a very specific. Those are the things we can control, and that we can do probably pretty quickly. We can say that they're in this hour. You have to be in operation during this time frame. You can't be open until midnight. You're only open until X amount of time, until 6 p.m. You know, those are the things that we do have in our control that we could probably put together very quickly, and then basically also piggyback on some of the things that some of our other communities or some of our other municipalities are doing really well that can put that stuff in place. But still, we're following, you know, we're heading in a direction that we have control in and that we can do that we think is best for us. Because what some communities are doing is best for them. It's not best for.
I agree with all of that, but I also wonder, since the council may be willing to reconsider its decision, if it would be interested in our recommendation. Like, we have been given direction to this point to develop an ordinance and to do it under the structure of a moratorium. But also we have other information is emerging that has changed some of the timelines. And so what I'm wondering about is whether it is worthwhile to actually recommend to the council, which meets on Monday night, to reconsider their position based on our discussion and potentially recommendation, to instead opt out at this time in order to allow us to properly study and develop those ordinances, maybe more along a 6-month timeline than a 3-month timeline. I just think that anytime any governmental body, and ours being one, is working under pressure and has that kind of a tight timeline, mistakes are going to be made, and then it can be very complicated to fix those mistakes. If the council decides, no, we really want to go back to what we asked you to do, well, then we can, you know, follow that direction. But I think it's worth requesting them to reconsider, and that would be, you know, my position at this point.
Thank you.
Mario?
Yes.
Have most communities opted out?
From our firm's experience, and actually after our meeting here with the MML representative, I sent an email out to everybody in the firm. I said, oh, by the way, September 1st, might be able to start accepting. Not a lot of people that let me know that they're suddenly concerned and scrambling, because most have opted out. I would definitely say the majority of our clients have opted out of recreation.
And those are the ones that have opted out, have they started working on an ordinance?
No. Well, excuse me. One has, and they came into some issues with their adoption and approval process, because it was going back and forth between the planning commission and the township board, and now their township attorney has told them, I need to take this into advisement. So some of them are attempting to deal with, to allow for them, but the time frames kind of impacted their processes. But the majority of our clients have opted out.
So some of the research that I've done is that there's 400 communities that have opted out of recreational and have, and then basically opted out of, from my understanding, the medical as well. And there's 115 communities that are allowing medical marijuana and waiting for what's happening with recreational. Because a little bit, by no means do I know what I'm talking about, but I have talked with Pontiac, I have talked with Flint, I have not talked with Harrisville yet, but also I know there's Orion out there. So from my understanding, communities that have accepted or opted in that have a medical plan, that the medical and recreational will eventually somehow merge together at some point in time where there won't be medical and there won't be recreational, it will be one. But once again, I by no means am not an expert, but just from the research that I'm doing, there will eventually be only one guideline.
Do you know why you haven't talked to Harrisville? Because I think they're open 5 minutes a day. I've tried to call them so many times. very part-time. Because I couldn't find anyone who had started an ordinance either. And I talked to the MML, they had nothing, but they're very interested in a copy of ours when we write it. You're welcome.
Yeah, you know, and a lot of them, a lot of the communities are waiting to see what the state does,
Right.
and waiting. But the ones that do say, all right, we want the medical side, and then they'll adjust from just the few that I've pulled or that I've talked with, that they'll adjust the recreational once that comes out to fall in line with the medical.
A couple of things with regards to that. At least 2 of my communities actually do allow medical marijuana, and they have their own different rules. I know for one of them, it went through an extensive process, it took them a long time, and they have amended that multiple times. The other community I just started in, they haven't amended it as much, but they're both allowing medical marijuana facilities in their communities. When it comes to the combination and eventually of medical versus recreational, you know, from a layperson standpoint, it does kind of make sense, because whether a person walks into an establishment or the product is being created is for an adult with a caregiver card, or with a registered patient card, because they need medicine, or if it's an adult that's allowed to utilize it under this act, you know, what is the difference? The issue, I think, might be in terms of getting all that eventually squared away and how it would affect local municipalities, is the fact that the other municipalities, they've specifically allowed medical marijuana under the Medical Marijuana Facility Licensing Act, and they've specifically opted out of recreation under the Marijuana Regulation and Taxation Act. So while the policies at the state level to approve those facilities might eventually merge easily, I think, I would hope, to protect the individual municipalities, there would have to be another state statute that would equate them. Because if not, then suddenly does a medical marijuana facility automatically become a recreational provisioning center as well? A lot of municipalities would say, well, no, why are you changing the rules on this thing like that? And I think it would take a state statute, but I'm not an attorney. But if that were to happen at the state level and they started, and a medical facility started saying, oh, we're just selling it to everybody, some municipality out there would have to take it to court to try and then it might have to develop that way if it wasn't done by an actual state statute.
So, with Orion, now, they're doing a grow in Orion, right?
Yep.
So they don't have an ordinance to allow that facility there?
No, they do. They have a medical marijuana facility act ordinance that allows for the grow facilities. I think they allow grower, processor.
So it's right here. So what they have no, so they're not allowing.
No provision.
So there's no cap on how many grower class A's. There's no cap. So meaning that many as they can have, issue as many licenses as they want. There's no cap on class B. No cap on class. Now this is medical, by the way. No cap on class C. No cap on processor. Provisioning centers. There is. Excuse me. Let me take that back. I was looking at mine. Excuse me. So, Class A, they have 0. Class B, they have 0. Class C, they're allowing 6 grow facilities, 6 licenses. Processors, they're allowing 2. Provisioning centers, they're allowing 0.
So that could be a
State
start for
compliance,
us to start saying that we don't want to have any grow in the area.
Absolutely. I mean, that's definitely, and remember that's medical. Under adult use marijuana, we can definitely limit what establishments we can and cannot commit, because that is the intent of the zoning ordinance. The zoning ordinance says these are the uses that we will and will not allow in the
So it would be the recommendation of this planning commission, whatever was decided, to tell village council that, you know, this planning commission doesn't believe we need a marijuana grower. Or we do. Or we don't want a safety compliance facility, or we do. And if we want either of those or don't want them, by definition, you would exclude them.
Correct.
So then, once you just, once this planning commission decided on ordinances for those, you would then go into your permitted uses and licenses. Then you would do locations and districts where permitted. Then you would do special requirements like setbacks, surveillance, window coverings, whatever it is. The third, you would have to do submittal requirements and a review process and standards for approval. So with no direction from the village council that says, pick 2 of these 7, we should pick all 7 of them and write an ordinance to fit
Decide if you want them.
those 7 definitions.
And when do we start doing that? When do we start taking a vote on whether we're gonna allow it or not?
I don't know that it's our determination to tell village council that we don't want growers here. I think we have to come up with some sort of an ordinance if you had them there. This again is the working body. The village council, with all respect, is the ones that bless it and give it the go-ahead.
I disagree with you. I think, what a surprise.
No.
What's the big grower though? What are the 2 grower things?
Class A, Class B, Class C.
If we decided we don't think there's a piece of property big enough for a class whatever license, we put that in the ordinance, that we don't allow Class B because there's no property big enough. And we just have to be able to
And that would be in the
justify that.
recommendation.
Right, and then we put that in the ordinance, send it to council. If we don't think we want a trucking company for whatever reason, and we can justify it, I think we put that, because the village council can change. Well, that's why we have the public hearings. If we put in, we don't want trucking companies, and PMS comes in and says, we want to do this, the village council can change that.
That makes it easy for us to do, Mo.
Yeah, I mean, I think that's absolute, that's what I expect from us, I guess.
If we recommend to the village council that we don't want marijuana growers because
Right.
there's not enough industrial property, there's not enough separation between
I think
church
if we
and
can,
school.
we just
there's-
justify it.
You can justify that, you would make the recommendation to village council that we didn't do an ordinance for growers because by definition, we're not allowing them because we don't have a place.
We don't allow, just about the only use we don't allow in the village is heavy standing.
Yeah.
Because we can't put it somewhere far enough away from a residential district that they're not gonna hear it.
But that's, to me, that's part of the study and, laying out that rationale, which I think is what the public needs to know about too. It's not just between us and the council. I think that's part of the acquiring information and just, discussing it and determining what seems to be the best way to interpret this. It's my concern that that can't be done quickly and in, a half hour's meeting. I just worry about doing a good job at that with the limited time we have. So I guess I already made that point.
I think making a recommendation, if you want to make a recommendation to council that we opt out because we can't meet the time, but we will continue to work on this so that in 6 months we are ready. I think if that's what the planning commission wants to do, I think that's completely acceptable to tell that to council.
Yeah, I'm going to agree with you, Mo, because with this draft laid out like this, and with the interpretation from Terry got from the lawyer, your emergency meetings, this is not a qualifier for an emergency meeting.
I would think you're right.
So, I'm all for if you give me an assignment, let's get it done. But if you don't have time to do it, face the fact. If you can't have, if you're down to 1 council meeting, so you're gonna have 2 before September. And we're looking at the September date, but by law, it's the December date. Now, if they move that date up on you, they've moved the goalpost.
Right.
What do? You're still working on it, but you're not trying to get the ordinance in before. You can't get it in before September.
When is our
According to
6-month
this.
moratorium up, Terry?
I think it went into effect on April 16th, so it'll be 6 months from that date.
So the middle of October, that's an extra month. And I don't know if Bob says if that's gonna fly with the moratorium as we write the ordinance or not. That's,
I heard no, but, you know, he could weigh in on that again.
Well, we could still be working on the ordinance development if we were under opting out prohibition as well. There's nothing to prevent that at all.
No?
to me, the bigger kicker is the whole regular meeting thing. And that just
Yeah.
cuts our time in half.
Other communities have opted out, but with a sunset clause, and they are crafting an ordinance, and they had to give themselves an extension from that sunset, but they thought the best level of protection for them was to opt out, but have a sunset, so that way they could be working on it, because some of their board wanted to have it going, and the planning commission actually said, can we get a few more months? And the board gave them extra time with an extension of the sunset clause. So that's just another way that other communities.
Yeah, I mean, I don't think the village council is unreasonable. They wouldn't listen to you. Well, listen, we just found out we'd have to have this done by July 1st, and that's just not possible, so, you know. So,
Go ahead, Rose.
I'd like to recommend to the council that that they opt out to give us more time to,
Based on the knowledge we've gotten tonight
this,
about a
adoption
timeline that's
schedule.
not attainable.
who let the dogs out? I had to do that.
that's reasonable to everybody.
And you are not interested or worried about a sunset clause, as Mario was talking about? You're just recommending, your motion is to opt out?
Yeah. Well, what would the sunset clause do us?
Basically, what a sunset clause does is that the ordinance that you pass it expires by a certain, well, once again, number one, the council would be the one passing the ordinance, if they opted out. And one of the tools in the council's,
So the council will have to initiate the sunset.
right, and the
We could
council,
opt out until January 1st, and then January 1st we have to have an ordinance in place.
correct.
Okay.
Yeah, and the sunset clause says this opt-out clause will expire on January 1st.
But we could make a recommendation of a time frame that we think is reasonable. I mean, that helps them understand what we think we can do and how much time we think we need.
I would like if we put a time frame within there that, which we could do.
Okay. Somebody have a time frame in mind?
I'd rather not do a time frame just because I think we need to take the time that we need, and I think we're all looking forward to working on this, and so I think I don't see us just pausing and stopping the work, so.
Signed ordinance.
Yeah, I'd like to say, as a member of the beach council, I will recommend council.
And let council decide whether or not we need to have a sunset ordinance or not.
I've seen way too many ordinances just thrown on the back burner until I never get back to the house.
Our
And then as-
direction from council was to work on ordinances for this. So you're making a motion to send back to council that you opt out with a sunset clause. In the meantime, we're still working on the ordinance. That's clear? Does that sound logical, Mario?
I would include that because, number one, if they don't do anything, if they choose to continue with the moratorium, the village is still showing some progress by working on the ordinance continually. But also, it also shows to the council that you're in keeping with their other motion, and which is to work on an ordinance. So the planning commission probably should be working on the ordinance as directed to the council. But like you said, based on the knowledge of potential applications received September 1st, and based on the knowledge that standard ordinance adoption requires 3 months of public hearings and publication, that the September 1st deadline cannot be feasible.
Well, that's clear, very clear. That's why the motion was made, I think. But under the direction of the village council, we will continue to work on the ordinance.
Right.
Like tonight, we could agree and disagree and agree to disagree on which one of the 7s we might want or not want.
Yeah, I don't really see it.
So we are, that would give you a chance to say, okay, we're working on it.
Yeah, let's call for the vote on this here before we discuss additional.
So, I call for the vote, and
I think you should do a roll call vote. If you're doing a recommendation.
Could you restate the motion, someone?
so based on the time frame received
And the planner.
from the planner, we make a recommendation to village council
That we opt out
that we opt out
while working on the ordinance. Because we cannot meet the September 1st deadline imposed by the state, probably imposed by the state, based on meeting schedules. Terry's getting it, she's recording that.
Oh, gotcha.
The sunset clause and suggesting they propose a sunset clause, or you don't think that needs to be in the motion?
I don't think that needs to be in the motion. I think.
What do you think, Leslie?
Sorry?
What do you think?
I don't think it's necessary, but I think because we're emphasizing that we plan to be, our intent is to work on this during the opt-out period. Unless Mo would suggest that the council needs that extra.
I would prefer the council, I don't think that'll be a problem.
Okay.
Roll call?
Okay. Cook,
Yes.
Ballard,
Yes.
Curtis,
Yes.
Bama,
Yes.
Helmut,
Yes.
Pilot,
Yes.
and Douglas is absent.
Now I can say it's the only one who didn't vote to opt out.
No, I think that we need to start looking at the 7 things that Curtis brought up. Yay or nay, or
So starting with the types of
Well, yeah.
establishments and then.
Sorry, you're right.
So what are you asking, Rose? I'm sorry.
I says we should start by indicating whether or not we want to see a grower in the area, yeah or no?
You know,
Do we want a microbrewery?
take, what Rose is saying, take the 7 categories listed in the document and start talking about if you want them or not. Or if you want to make an ordinance to allow them or not is the proper word.
A couple of things for your information then about these potential uses. As I mentioned, the act has a little bit more, has different definitions than medical marijuana. For adult use marijuana, they have a broad marijuana establishment or definition, so that's for all of them. And then they don't specifically define grower A, B, and C, it's just a grower. They don't list it by any kind of quantity at all.
I think they do. I think there's
No,
still.
no, I read your number.
Yeah, I thought they limited the number of plants. It's still very similar to medical.
Yeah, I mean, and that's definitely the intent, and it probably will end up that way. But specifically in the act, marijuana grower means a person's license to cultivate marijuana and sell or otherwise transfer marijuana to marijuana establishments. So that's what a grower is. Marijuana micro business means a person's license to cultivate not more than 150 marijuana plants. Process and package marijuana and sell or otherwise transfer marijuana to individuals who are 20 years of age or older, or to a marijuana safety compliance facility, but not to other marijuana establishments. Process and package marijuana. For example, their definition, they don't include a provisioning center, but it's the same thing, it's called a retailer. Marijuana retailer means a person licensed to obtain marijuana from marijuana establishments and to sell or otherwise transfer marijuana to marijuana establishments, and to individuals who are 21 years of age or older. They do define a secure transport safety compliance facility. So, at that point, you're just splitting hairs, because you're right, the other types of facilities are similar, or probably will be exactly like the medical marijuana, but I really think if we first base all our language and information on the actual act, that'll provide us a good basis to start with. And then I just want to read the establishment one, because the establishment, I think it's, so marijuana establishment means a marijuana grower, marijuana safety compliance facility, marijuana processor, marijuana micro business, marijuana retailer, marijuana secure transporter, or any other type of marijuana-related business licensed by the department. So in this particular case, I would say, you don't want to say marijuana establishments are allowed in the village. The ordinance would say the following types of marijuana establishments are allowed within the village, and then you tell me if you want a grower, a micro business, a processor, safety compliance, those things.
Is it possible to have the discussion about permitted uses before?
Yeah, it kind of wraps itself.
Yeah.
Those two definitely wrap themselves
It
together.
feels hard to me to determine what a grower definition should be when I'm not sure what uses work best.
And until the rules come out, and until they be more specific to define the quantity in the rules, I'd say you just go with a statute grower. It's just a grower is anybody that's growing marijuana. Cultivate marijuana and sell or otherwise transfer marijuana.
What about or any other type of business?
Well,
That seems so vague.
Right, and because that's so vague, that's why I don't think we should use the definition of a marijuana establishment.
Got it.
Because then we could open ourselves to whatever rules come out with a new type of establishment. So the things you should consider is specifically a marijuana grower, just grower in general, a marijuana micro business, like whether you want that or not, because that's listed specifically in the ordinance, a marijuana processor, which basically it's where they take the plants and they take out what they need to do to create the actual products, whether it's an infused product or whether it's just the flower that smokes or whatever.
So Mario, if we don't allow growers, they'd have to say that Orion's growing. So they would have to go to Orion to get the plants, bring it back here in order to process it.
If you allowed a processor, like if that's what you wanted, if you wanted to say, we don't want a grower, but we'll let someone buy, exactly like you said, Rose. So we'll let someone go to a grower, bring it to their processing facility, and then they can either then take it somewhere else, or in theory, if you also allow retailers, they can sell it as a retailer. One thing I'll tell you that eventually came out from the medical marijuana side, and they felt was appropriate, is to limit those kind of trips and to limit the amount of product going through the various streets of the state. It's basically called a stacking of the uses. So and the state eventually agreed, and that's how they're basically starting to allow them in. Is someone applies, but they apply to be a grower and a processor and a provisioning center. So therefore, all your activities are in one building. That's another thing, is that all these activities are definitely within an enclosed building. No one's being allowed to grow for a facility anyway, out in their yards. Residents can. But for facilities and the size and scale of the facilities, most of them have gone for that type of operation, because then it's like a soup to nuts kind of situation. I don't know if that's vertical or horizontal, I don't know how you call that, but that way a business that's established can do that. I do know one other community that does allow just the provisioning center, and in that case, they do have to go get the plant from a processor, because it's been grown, it's been processed, and then they sell that in the retail establishment. So that's another option.
So that's like the micro business idea that's allowed, so it's.
But on a macro scale.
Okay, yeah, because they can cultivate, not more than 150 plants, and then they process, package, and sell it right all in the same building.
So for example, to get into more specifics, when it comes to medical marijuana, there are some facilities right now that we're looking at going into operation. They're doing the 3 types. Technically, they have to stack the license for the growers too, because the growers are limited to 500 plants. I can't remember the number. But this one particular facility, it has about, it's gonna have enough square footage to allow for 350 plants. And then it's gonna have a processing facility adjacent to it, and then it's gonna have a provisioning center next to it. That entire facility is approximately, I know the grow part is 8,000 square foot. It's a 12,800 square foot building. Technically, we don't have, I'm not sure why, lot coverage requirements in our industrial district. But if you had a normal lot coverage requirement of say 30% for a building, then you're looking at basically a 1 acre site. A 1 acre site would hold enough space for a provisioning center, a retailer, processor, and a grower that would grow about 350 plants. At least in this one example. They have, in these facilities, all their operations are governed by state rules for medical marijuana, so they have everything specific, what they need to have. They have to have specific areas for storage, locked storage. They have to have specific areas for disposal. Like disposal is a very big, key, important aspect of these uses. But in the end, what happens is everything's done in one building that's 12,800 square feet, around that size, and everything fits in about an acre. And I can tell you one other thing about, personally, what I think an important question for you to consider, number one, when it comes to retailers. When it comes to adult type of uses, and even adult uses, such as, strip clubs and that sort of things, their proximity to other retailers and other offices and other types of general uses, say, found in downtown, have been found to be detrimental to those communities. Because in the past, when those types of uses were allowed within a more general commercial environment of a downtown, it kind of impacted the businesses, caused them to close, that sort of thing. So a normal practice, planning and zoning practice, is to allow for the more adult uses in your industrial areas. Because those adult uses are permitted by right, by the Constitution, according to the Supreme Court. So we have to allow them somewhere, but once again, zoning gives the village the possibility of where to put it. So, and it's worked in other communities where you do allow it, and you allow it in your industrial area. And the industrial area is capable of handling traffic of those types of things. Okay.
The only thing that I've seen so far is the statute and the recommendations from Mr. Davis. Is it possible to pull together information that would help us understand what the pros and cons are, what, like you just laid out, that a 1 acre site would be necessary to do. So is there a way to pull that information together so we understand that when we're discussing what uses we should permit, et cetera?
Sure. Probably the easiest way would be for whatever, when we have our discussions, you guys give me your questions. And if I can't provide you the answers right now, I can provide you that kind of more detailed analysis of
As we go
forward.
Okay.
A lot of that stuff comes from just research in your own interest to read articles and find out what other facilities and what other places are doing, and that's because there's limited, all-encompassing information. So you get some from here, and you have to get some from here, and you have to get some timing from over here, and kind of put the puzzle together of your own idea of what's best.
Which I understand, but I kind of feel like our planning consultant is the ideal person to try to distill that for our benefit. Because I'm not sure I know how to make sense of all the data that's out there, not being a planner.
I didn't as well. It's just more or less, having to spend time into researching and doing those things. Once again, by no means do I know like everything or anything and all that stuff, but I have really educated myself on a lot of the different aspects of those things that we're thinking
Right.
about. So.
And I would like to be educated too, but I just want to, you know, I don't want to reinvent the wheel personally either. So if there's a way that we all can benefit from similar information, so our discussion can be comparing apples to apples, I was just trying to find out if there was a reasonable way forward. So we could personally research, or you could prepare information for us.
And I can definitely prepare that information. Like I said, if you have specific questions for me, I can prepare that as a response for the next item. But also, I think it's important to try and understand that, you know, once again, we're dealing with the zoning aspect. And if, even though technically the ordinance starts out with definitions and permitted uses, because they're wrapped together, when it comes to these basically 6 different types of facilities, you as residents, you know, should think to yourselves, where would I want to be okay with seeing these type of uses located? So for example, as Mo mentioned, we don't allow stamping plants in the industrial district, heavy stamping, because in the past, the planning commission said, industrial uses, we obviously need them for the jobs, and we obviously need, you know, certain types of uses, but when it comes to actual heavy manufacturing, it just doesn't fit in the village. So when it comes to a grower, you know, when you think about the grower, the number one about it is, and it's accepted practice at this point for medical marijuana, everything's in an enclosed building. So when it comes to a grow facility, it's a matter of whether you feel, A, how big it's going to be, and then B, where that scale and mass of the building would be located. And obviously, and when you think about it, they're basically taking something and producing a product. So just whether they're producing widgets or producing marijuana or producing, you know, tooling, you know, screws. You know, generally when it comes to a production facility, it belongs in industrial because of just the size and scale of the building, and you know, you don't really want to be living next to a massive building that's got the potential for a larger scale of buildings and operations and how, you know, how their hours are operating. So you think about where you want to see it go, and if you don't even want to see it in the village at all, then that defines your definition of what's your permitted use. And I just don't think it should be in there.
Maybe we can agree upon what we want to focus on, and whether we as a commission can agree upon what we want more information about.
Sure.
What we feel as a group we want more information about, instead of, you know, my personal take on it.
Yeah, I think that's a good idea, and I like what Will mentioned before too, is like some of these could possibly be ruled out just based on the availability of locations that we have. So it looks like there's 6 for us to consider in the statute. They are defined, as you pointed out, so we have a little bit of guidance, but they're kind of loose, you know.
Are there 6 or 7? The numbers seem to change every week.
7 is the other related businesses, so.
Okay, that works, okay.
Yeah, and so I think that, if
So
we can-
what are the 6 then?
So it's a grower, safety compliance facility, processor, microbusiness, retailer, and secure transporter.
The safety compliance is what I was missing.
So on the retailer, would there be a place in our downtown for it?
You know, it's up to you in terms of, you know, the aspect of retail, and because retailer basically means someone walks into a place, they peruse the products, and then they walk out with the item.
Now, does it have to be
Yeah.
a locked facility?
Well, that's the thing, is that when it comes to medical provisioning centers, they are, the rules for the medical provisioning centers are very secure. There's a way, because also the nature of, well, not the nature of the product itself, but then also because the only people allowed to look at and choose the medicine have to have permitted, have to have a caregiver, a registered patient card. So basically, it's like a doctor's office. All these places are going to have a secured entrance. You walk in, there's usually a person greeting you. Then there's a seating area. You sit down, and when your name is called, you get up. You go through a locked door. That door closes behind you. You go through the second locked door, and then you go into the retail area. And then that's where all the marijuana is. And then there's experts there that talk to you about your issue and what you think you need for how you want to adjust it, because they sell infused products, they sell these oils. Some things I'm not sure you're supposed to use it, but then there's other, and then they have regular old marijuana that people smoke. And, you know, and so they go into there and then they come out to secure facility. And then
So that, would we want to implement that type of thing for this also, for the recreational use?
I think that's probably, I would think probably that's a good decision soon, because right now, the dollar value of such a product is pretty expensive. When you think about other type of uses that are like that, it all depends on A, the type of community, and B, the item. For example, in Chicago, when you go to a jeweler in certain neighborhoods, you knock on the door, they buzz you in, the door closes behind you, and you get buzzed back into where the jewelry is.
But I think that's with any business. I mean,
Right.
Your potential for crime with any business is just,
Right.
it could be anything. I mean, you
Yeah,
can-
well, we've got a jeweler in town now that you have to be buzzed in order to,
That's their choice. I mean, they chose to do that based on how they feel. And so, I mean, that's not something that I think that's, you know, really at the end of the day, this is as if any other business is coming into our community. And we probably won't eat, let's say if we did allow a grower, we probably would never even notice or even know that there would be a grower in, let's say, in an industrial area, because they're conducting their business in a manner of which it's inside the building and you'll never see it. Maybe now a provision center or a retail place, all right, yes, because you would have signs and you'd have certain things and you'd have people, but from a regular community standpoint, most parents won't be taking their kids into a retail facility, right? They're not, and so those are the type of thing. Once again, it's just a regular business, as if it would be any other business that would be within our community. And it's a really cool product right this minute, but at some point in time, as time goes on, it's not going to be taboo, and it's just going to be a regular product. So we kind of have to think of it, I mean, me personally, you have to think of it as, where would I want this type of business to be at in my map, right? Where would I want this to be within my location, in my community? Because, and that's the way I'm looking at these things, is what's best fit of these things? Because I don't believe that all these things fit best in our community. And that would be one thing that we would help to maybe suggest for those things.
Can I give one that I think is simple? In my mind, it's the transport. I can't imagine telling a trucking company what they can and can't carry. I don't know, we have, trucking is already allowed in the village, in the industrial district. To me, I don't think it makes a bit like a difference what they're carrying. Because they're gonna pick it up, they're gonna take it somewhere. They're gonna drive to Dayton Street, throwing it out the windows.
So a transport, yeah. So basically, from my understanding, a transport would basically, they go to Orion, pick up whatever they need to pick up, and then take it to a processor, wherever that processor would be. And if we don't have a processor in our village, they're not coming to us. They're coming someplace else. And if we don't have a grower in our facility, it's basically a vehicle going from point A to point B.
And I guess there's a potential of having to hold it overnight for some reason.
I'm sure that they're based on the rules, the
I don't know
business
what
has their own
yeah.
rules and regulations, and I'm sure it would be like similar to maybe a armored car. They would never leave money in an
Right.
armored car. They
Right.
would have rules and regulations.
It seems like there's, in most people's minds, there's a difference between a retail experience and then the production end. It feels to me, and you seem to be suggesting that retail, I don't want to get this wrong, but it seems like you were saying that some communities have experienced that retail adult use establishments seem to be better in industrial areas. Did I get that right?
Yes, and I think, actually, Justin, you had a good point too in terms of, you know, right now there might be some taboo to what it is, and kids aren't going to be, well, kids probably aren't going to be allowed, under 21 probably won't be allowed in this stuff anyway. But one similar thing I would equate it to would be alcohol. Alcohol, you think about alcohol places back in the day, I'm not saying back in 1940, you know, they were only allowed in certain places.
Let's use today's example and go through these 7. Number 1, marijuana grower. We don't have a distiller in town. You're in Tennessee, Kentucky, we don't have a distiller.
Well, we have
Oh, we do have
Brewery.
breweries.
We have
I'm sorry.
breweries. I'm talking just alcohol as in liquor. So you have a liquor, and let's just use liquor, and I'll quantify that. Marijuana grower, okay, so we don't have a still where we're brewing liquor, which is state controlled with Liquor Control Commission. We don't have a compliance facility for that liquor, but yet Tennessee, Kentucky do within their own facilities. They don't have a processor. We don't have a liquor processor here. That's a person licensed to obtain a barrel of it from Jack Daniels and break it down into bottles. They're all done internally somewhere else. In our community, though, we do have microbreweries and a person licensed to cultivate not more than, or a limit on the number of barrels or plants. And then you can package it and sell it, just like our microbreweries.
I see your point.
Now you get down to the retailer, and here's the point that I'm trying to stop from going crazy, is if we don't have this regulation or ordinance in place, the guy that sells ball caps in C2 can go to the state, get a license for selling marijuana, and sell marijuana right next to his ball caps. Just like CVS sells alcohol, just like Sunoco sells beer and wine. So, you want to prevent that? Do you think that we're going to have one marijuana establishment and that's all they're going to sell? I don't know. Then the transporter, that's just like our liquor distribution centers that we used to have. You had a Michigan LDC on Perry Street, Pontiac, where the truck pulled in and they brought out hundreds of cases of Jack Daniels and then took those to places that would distribute them to the party stores. So we don't want some of this stuff here because of its scale, but how do you keep it out is with data zoning in your ordinance. Okay, perfect point, a grower. If you need 20,000 square feet to grow the maximum number of plants, are there any properties in town that you could put a 30% coverage and still have a building on? And if we determine that there's none, well, that's our fact or our data to ordinance them out. We just can't say, it's my personal feeling, we don't want growers here. No, we don't want growers here because there's no property available that less than 30% coverage to maintain the maximum growth of 500 marijuana plants. So in our ordinance, we would say by definition, it would be an industrial, but since all our industrial properties are built out or don't have the capacity to handle one of those, we elect not to do it.
Which is part of why I guess I was interested in information about, like, what is the square footage requirements, what are the infrastructure requirements and so forth, energy requirements, so we know how to make reasonable, right?
Well, I think, while that's definitely a way to go in terms of the analytics of it, it does kind of drill down very specifically into the business and operation of how they go. Those numbers I gave you was based on one operator's proposed business plan and their proposed need for the number of plants that they needed. They felt they needed 366. So while definitely it would be a very good analytical exercise, I don't know if you need to get down into those specifics. I think it is a little bit more like how Jack was saying in terms of how comfortable you feel with just those. Number one, not even getting into the size and scale of it, although it will be a factor. But if you're comfortable with them in the village, like a grower, as Justin said, grower, it's basically inside a building. You're really not going to know what's going on, but it will be, a facility that's growing marijuana. So it's a matter of whether you feel that's appropriate or not. And I think, not to get too much into it, but I have already done some site analysis and some setback standards and some zoning districts, so I kind of already know where they can.
Do you do Chesterfield Township?
No.
Chesterfield Township, they had a block of industrial buildings that a guy went in and bought up. And he bought every building on the block, and he's growing marijuana.
Yep.
He didn't care what he paid for the buildings. If there was a dye shop, paint shop, he bought all the buildings. So it could happen here. I don't see that it would, but it could happen. Somebody comes through and buys, tries some Tool Tech, the old Royal Oak Boring building from the Stannis guy. He could buy them all and then just start growing pot. So if you say that due to the current statistics in our village, we don't have the square feet capacity to grow facilities, we're gonna ordinance them out. We have to have some logic to ordinance them out. You just,
Well,
Let me,
I'm sorry.
let me just ask you this. So based on that, you know, we can still only allow X amount of licenses for that, right? So let's say we do have the capacity for a grower, we could say we only want one license and that's it. So we could have that option.
just for your information, the square foot of the grow facility in Orion is 278,000 square feet.
Yep.
Right, but I think, Jack, I hear what you're saying, and it definitely, from a legal standpoint, if you wanted to talk about the basis for substantiating the quantity you guys would permit, sure, that would help if there were a lot of statistics behind it. But number one, like you said, when it comes to these, and when it comes to even adult uses and strip clubs, basically, the key providing factor is that we're not held for the vagaries of the real estate market. If there are that string of uses of lots and somebody comes in and buys it, there might be one person right in the middle of it that says, no, I'm not selling. He's like, I'll give you $1 million. I'll give you $1 billion. I'll give you, I can afford it.
Yeah.
The person could say no, because that's the vagaries of the real estate market. The village can't get into the vagaries of that and whether they can or can't do it. But you can, as Justin was alluding to, because the state gives you the power in this ordinance just to say, we're going to start out with one. You can say, we're going to start out with one. We can say, we're going to start out with 5. You can do that, and then, now let's say you decide, oh, we are going to allow 20. Well, then that's when the land and the size of the village is going to factor into the fact that you probably won't fit 20. I can tell you that based on normal other things as we get into it, the setback requirements and zoning and what's currently zoned, there are going to be a finite number and a small number of places where locations in the village that could fit. And in the end, I think, I was going back to my analogy about alcohol. Right now, there's bars all up and down, Washington. There are different places that are sold at gas stations. They get alcohol sold at gas stations now. But back in the day, they were more restricted. They were more, bars were, I have ordinances that say bars and taverns are deemed a adult regulated use and shall only be located within X number of feet of a school and everything. Now, not so much. So, in the future, it probably, chances are it'll get more, potentially more acceptable, that it might not be. So for you, like you're saying, the statute gives you the idea that you can just say, we're going to start out with X. And you can just say, we're starting out with X, and this is where they're at.
And I think that a lot of the public would look at it more like beer and wine than it would like hard alcohol, just to come back to that metaphor, because I think the microbreweries and the kind of the sense that having a beer is not, having a half a bottle of whiskey. I think people do draw differences in that in the community, and that may make some of what we're deciding a little bit easier, but it also In a lot of ways, it doesn't matter because it's legal to use it and it's legal to have it on your person and it's legal to grow it. And the question we have to decide is where can we provide for these uses if we can, how many, and then let that begin to take shape. But I'm absolutely no expert, and I don't think I have the capability of doing the kind of research that you obviously did, Justin. Thank goodness you did. So I want to bow to the experience of other communities, to how they're addressing these same things, so we can adopt the same kinds of approaches, and maybe, as Mario is saying, start small so we're complying with the law and we're able to see the consequences and the implications of if we're allowing only certain numbers of establishments and what kinds. So I guess in that line of thinking, I just had one more question, which is, you were talking about stacked uses. Are there ordinances that allow that or require that in any way?
Yes, for medical marijuana, some communities have opted to say, they say, we're going to allow 3 medical marijuana facilities. The first facilities allowed are grow facilities. If someone wants to be a provisioning center, first, they must be a grower as well. And then if someone wants to be, a processor. And then if someone wants to be a provisioning center, it can only be in the same location as both a grower and a processor.
Okay.
So it's encouraging stacking, but it's not requiring. So, for example, in that community, they could have 2 grow, and that's all the person wants to do. And then they have 1 with a grow, processing, and provisioning all in one location is a complete thing. And based on all those combinations, they can do that.
Kelsey, you had a question?
Yeah, thank you. So I'm thinking back to the town hall we had, and it seems like one of the public's concerns was not having anything in the immediate downtown area. And Mo even asked for, what's your definition of that? So I'm wondering if there's even a consensus among us now that maybe we, exclude that area and focus on the commercial area. And then the other point I wanted to make is that a lot of people were interested in the potential revenue that it could bring to the village. And the 10% excise tax only applies to the microbusiness and the retailer. So if we're looking for, what potential money we could get back, we want to probably allow those ones and find a place for them.
And the licensing.
I'm sorry?
The licensing could be a lot of funding
Right. Yeah.
for everything. But I'm only really looking industrial for this.
Okay.
And I think it's a major street, it allows truck traffic. So that lets out these little industrials, they're up here, because they're not on a major street, it's a local street. I'm a little concerned about this one here on Lakeville Road, but it's not a very big piece of property. I don't think, we definitely don't want it in the 2 main blocks of downtown. And I would prefer not to have it on M24 at all, but that's just me.
So you're basically saying industrial I-1?
Yes.
Everything I-1 and nothing else?
Well, it's I-1, and then you start putting your regulations in. It also has to be on a major road. Gillespie Street's a major road.
Got it.
Loud Street is not a major road, so that lets these out.
Okay.
That leaves Gillespie outside the 1,000 feet and the little piece on Lakeville Road, which I think is our only industrial on major streets.
Well, so you just put some restrictions there that help me
Yeah.
get my head around it, let me put it that way.
How about if I offered this? What if we peel the onion from the other way? Marijuana retailer. That's the person that has to get marijuana processed, packaged from somewhere else and bring it and sell it in our community. That's where you generate your first stage of revenue, if you're going to get any revenue at all. You say, okay, let's put that in the C2. There's only 2 spots you can put it in.
Why would you put it on in C2?
Because C1 core is all downtown, C1 transition is
Why wouldn't you put it in industrial?
Your retail establishment?
Absolutely.
Well, now you've commercialized your industrial property.
I got no problem with that.
I know you don't.
Yeah, that's, I would kind of agree with you on the C2. C2, and because what that would allow us to kind of keep it in that, into that very specific location where it's not in our downtown. And it doesn't completely restrict your industrial aspect where you have an industrial, where you can have manufacturing in that facility.
And a lot of the C2 ordinances and permitted uses, or ordinances are written for C2 to allow the sale, and they control the sale of other products in that district.
So there's really only 2 spots for that.
Well, the one is the fire hall, so that really leaves you Frosty Boy.
And why was this crossed off in the C2 here?
That's what I
What was
thought.
the
That's a
reasoning?
school.
At the school,
Within
technically, there's
LLC.
a virtual academy in Oxford Marketplace. And I would have to check if that qualifies, but I think it would, because it's run by the school district.
Yes.
So it would be, and that's definitely a recommendation I would make, having a separation from schools. So having, because the only 2 schools are down on the south side, and then they would, and, you know, whether you choose 500 foot or 1,000, that would be pretty good separation. Okay.
But based on what you said a little bit ago, we could conceivably say a retailer must also be a grower.
Stack facilities, is that what you're saying?
Yeah, we could do that, and if that were the case, that there might be properties that wouldn't be suitable for retail because they're only suitable for growing, and if we made those 2 contingent on each other, for example.
Right, if you went that route. And it's really, I think you're dealing with the number one, the first question right now in terms of location, whether it's the industrial district or industrial and C2. Because I think that's a good first question for you. It's not asking how you feel. The benefit about both of them is that they're our most auto-oriented uses. They both will have off-street parking facilities that should be capable of handling the traffic. And so Jack, even though it is retail establishments inside industrial districts, it's not unheard of, just because generally speaking, you don't want like a straight retail character in industrial, because if you have that as a permitted right, retail uses in industrial, then you're gonna have that conflict of people having businesses that can function well in industrial, adjacent to industrial users. They're gonna have a lot of noise, odor, other things that are regulated, but they're still an issue for customers. Whereas chances are with this use, that's not going to deter anyone that's really in need of, or that wants to acquire marijuana. They'll go where they need to go. But the other alternative would be to allow them somewhere in a commercial district, because the commercial is for those type of retail options. But you're right, based on my analysis and looking at everything, you could have, you basically over next to Frosty.
That's Frosty Boy, Architects, Little Caesars.
Yeah, one over there, you'd probably have one over there.
Put in the cemetery.
You'd have one over there based on the physical and the separation requirement. One could be there and one could be on the north side. Because there's property located north of the fire station. That could work.
Oh, yes, you're right. The tanning salon and the other house,
In the big
McDonald's.
And so, yeah, those are your, if you wanted to allow just retailers as retailers, those would be the places they could go. And C2, or say not C2 and just an industrial.
investment or, by getting, like with McDonald's being an open vacant lot, somebody can come in, put an actual facility up, which then helps your community run based on tax rolls and,
I was just, FYI, only the parking lots in the village.
just.
The rest is buildings from township.
Right, that's a bad example.
But the Tanny Company is in the village, and the little house at 108 North Washington is in the village. And the fire department can run over there in their lunch and pick up their stuff.
I mean, but the thing is, based on, we still have a lot, I think we could talk about this literally all night long.
Absolutely.
So, I think at this, we have to really, each of us kind of have to really take a look at our maps and take a look at what the definitions are and kind of educate ourselves a little bit about, all right, where do we believe would be best fit for our stuff so that maybe we can come back at our next scheduled meeting that we have something to help, to contribute to say, hey, look at these are some of my ideas and some of my findings, and then we can maybe, hopefully, come to some sort of collective direction to continue moving forward.
Here's my question, kind of piles into Leslie's. If we're gonna have a grower in the industrial, and they're gonna process, are they gonna be allowed to have a retail?
I think that's one of those things that you have to think about.
Yeah.
You have to kind of
If they're gonna have
Talk
state
about it.
licensing, are we gonna allow it, because it's not the main portion of the business maybe, or?
It does help if we know what location and areas we're considering for permitted uses to help, I think, determine, how many different types of licenses would work in those locations. I think that could go that direction.
And basically, it's, as you just, but the thing is, the village is only so big, so there really are only those many options. The site on Lakeville would be basically free from any other restrictions if you allow it in industrial, because there isn't a school
Right.
within 1,000 feet.
And
It's,
the flex would be open too, right?
where's that one?
The flex district of the
Oh,
government.
well, no, we could just say industrial. We could limit it to just the places that are specifically zoned to I-1.
Okay, so they have to rezone from flex to I-1, okay.
Yeah, so we could keep it to industrial. The site in Lakeville would be, down on Glassby. There are, depending on separation distance, you could have as many as 3 in there. If you have a 500 foot separation. If you have a 1,000-foot separation, you probably fit 2. And then I was thinking that like the ones on the north, those are pretty established users, but at the same time, they could be. Actually, one other factor in, Leslie, for this is the idea that I would also suggest a 500 or 1,000 separation from other marijuana facilities. Because you don't necessarily want, if you're gonna start out with a limited quantity, one option they said is like, we're not gonna have a concentration of them, but we'll have them separate from each other. So if you did that, then if you allowed it in C2 and I1, as soon as one site goes in on the north side of town, then that eliminates everything else on the north side of town. But the problem with, not the problem, but the geographic separation for the C2 will still allow for someone to go over on the west side of town where Frosty Boy is. The only way you could possibly, if you did want to have that happen, is either not have it in C2 or limit the quantity. You could say one use allowed in C2, and then you let the market decide what C2 location comes first. So in theory, if someone over on the west side of town wanted to have happen, and if they were first in line, then it would go there.
Or once again, one in any of it, like in total, one.
Right.
Regardless
That's
of
good,
where.
yeah.
So
Yeah,
regardless
you
of
just
where, we
say-
only allow one, that's it.
And that's the other thing too, when it comes to the quantities. I have a lot of people when they're asking me in other communities, well, this community's only allowing 3, are they gonna allow more? I was like, right now, council has approved an ordinance for 3. That's what they're going with now. But in the future, at any point in time, if they feel like they need to have more, they just change the ordinance and allow more of them. So you could start with 1, and then add more as you have experience with the one facility.
You have a question?
How does the ordinance drafting process take place here? So once we start agreeing on things, who puts it into the actual written ordinance? You do, okay. So then you present it to us and then we can look at drafts and keep changing.
Yeah.
I work well looking at something on paper and then you can kind of figure out what you want to adjust. So at what point do you start, whenever we give you enough direction to kind of put something on paper?
It's when you direct me to. I can start drafting an ordinance based on our conversations, and then you can either be very specific with me with regards to what you do want to see in a draft ordinance, or you can say, you know, bring us a draft ordinance to react to.
Mario, you're not gonna reinvent the wheel. There are a couple communities that have them right now. You're gonna grab those and take a look at them
Yeah.
and present them to us in some sort of a...
Well, honestly, I thought there were more recreational, but there aren't more recreational. But I would say,
Harrisville and...
yeah, Harrisville.
Lapeer Township, and, I mean, that's two.
Right.
Chesterfield Township.
I mean, I really feel that when it comes to it, the medical marijuana, with all my experience with dealing with those facilities, it's generally the same. And I really feel those 7 topics are zoning related topics that'll craft a good ordinance for you. And then I know we didn't get down to that point, bullet point yet, or number, but the special requirements for the particular use and the submittal requirements, it will deal with, I would suggest basically requiring an applicant must first be pre-approved by the state before submitting an application to the village, something like that.
I think they have to already. You can't. I think they have to already be. I think they already have to have the state license already granted before they ever come to us and submit an application.
Right, but that's one of those things I want that protection in our ordinance, just to reiterate what the state wants. Because remember, the state rules have changed and they might go tandem and say you can apply for both at the same time because they changed it not for medical marijuana. But then that deals with a lot of the other issues with regards to the applicant and making sure to not put the cart before the horse. Because like I said, I agree that that's already, you're right, it's already in the law, that's what they have to do. But you never know what the state could do from a rule standpoint. They might allow for dual track approvals.
For our next meeting then, could you pull the ordinances that you can find that may be in place for us to take a look at? And then, I don't know if the other commissioners think of this idea, but to basically start an outline, start the draft ordinance, even if it's pretty sparse. I mean, if there's certain things in the law that need to be included in the ordinance, at least get those set up so then we can start filling the blanks a little bit better. I mean, whatever, even if it's a skeleton framework, just to...
You're such an attorney.
Very specific. Yeah.
Have we given you any information at all to start something?
Yeah. I mean, yes.
You could write the whole ordinance based on tonight's conversation.
I definitely could. I
Like
mean,
that, my desk by 9 tomorrow.
Do we need to summarize or in some way present consensus to you before we leave tonight?
you can if you like, but I definitely, you know,
You think you got
this
it?
is the first draft of the first draft of the first draft, so it's gonna change. So,
I have a question, Mario. Safety compliance, is that medical? Kind of leans towards the medical, checking to make sure it's not moldy.
Right.
that's what it is. It's basically making sure that licensed facilities provide a product that's free of the chemicals, free of various things, because they have caught them in the medical. Some growers have been, the product has been rejected because the safety compliance found too much ammonia or too much of this and too much of that.
I guess my question would be, where do we allow medical facilities or something like that in our ordinance currently?
Well, to me, from a zoning standpoint, that's basically just any kind of other laboratory. It's a lab, whether they're testing, you know, ammonia, or whether they're testing marijuana, there's certain equipment and so from a zoning standpoint, it's only about the size of the facility.
And where do we
parking
allow labs in the
requirement,
village right now?
Probably just in industrial.
Industrial flex.
Or flex. But in terms of that type of thing and making sure that the product of eventually provided, if it wasn't provided to the village, met safety compliance, we can just, the catch-all will be that any retailer, we could say, number one, before they even submit an application, they must be pre-approved from the state. And then we could say, as part of the standards for approval, is that this approval is contingent on the applicant receiving approval for their facility from the state. And any applicant that is in violation at any point in time of their license shall have their approval revoked in the village. Because we want to ensure continue compliance with all the state standards for that specific purpose, for licensing, for safe products, and that sort of thing. So when it comes to the testing, I don't know if you definitely could have them located in the state, in the village. I would think that the rules are going to allow any facility that's testing right now for medical to allow for testing recreational. And then because in the end, chances are, I believe they only have to send a small quantity to be tested. So there's probably not going to be that many state licensing, laboratory facilities. Because they're going to probably just be matter of,
So our next meeting is June 18th. You've got enough information to bring us something back by then?
Sure.
June.
Oh, yeah, no, we can. Well,
You do have items on June 18th, actually, site plan for Valley Ridge, and you have another sign for NODA.
no, I could. If that's what you want, but as there's two items on the agenda, it depends on if you want to include this.
But if we're going to keep going through this, we should always have it on the agenda.
It should be an ongoing agenda item, I agree.
And there should always be an hour dedicated to it at a meeting. I mean, I don't want to sit here for 5 minutes, talk about it, and go, oh yeah, we're working on it. We're not going to be able to have our meetings.
But at the same time,
Right.
we have to, because once again, it's one of those things we talk about this thing to death. We kind of have to really kind of be, I would say, really prepared and ready, but have some ideas of what we're
But if you could have something together by June 18th, so we can start ticking things off of it.
Yeah. Okay.
That's true, because if I came with you with my first impressions of these standards, and you can tell me, all right, you're way off base on this one, or okay, I can see this, or massage, if you want to.
Excellent. So any other questions or comments?
Just one question. This is always going to be old business. Is old business first? Is there any way we can change that on the agenda?
That's really,
Just from a courtesy, you have two people coming in here, one for a sign, one for a site plan. We're going to be talking about marijuana ordinances for an hour. They don't need to sit here and go through that.
I would agree with you.
No, we can just change the
I
agenda.
know how many
that
of
day.
most issues with me.
I do agree with you, Jack. Mark that on the tape, Connie. I think we just move it so that marijuana is always the last
It's just
item on the agenda
courtesy
before public
to-
comment. Go through the business,
Yeah.
then go to the ordinance.
This is gonna be like the sign ordinance, and I remember those meetings where we did that, and then we held a person hostage in the crowd until we got to some point where we could move.
All right.
That's all.
Do you have anything else on that related to that? Okay. Public comment? No public comment? Planning commissioners, any more comments?
No, I think we had a very good meeting tonight.
Excellent. So it's basically, commissioner comments or recommend to, Mario? Any more comments?
Oh, any more comments? No?
Okay. You talked quite a bit today.
Yes, I'm sorry. Sorry
So-
about that.
Do I have to recommend to adjourn?
I'll make a motion to adjourn at 8:40.
Second.
So we adjourn?
Get your vote. All in favor?
All in favor?
Opposed?
Aye. Any opposed?
Good job tonight.
Yay.